Live from Victory Park, this is News 8 Daybreak.
Now on Daybreak, the political fight of his life. New developments today on the Ken Paxton indictment. And when will the Texas Attorney General turn himself in? The clock is ticking as we are just hours away now from learning more about the charges against Attorney General Ken Paxton. The documents will be unsealed later today in McKinney. A Collin County jury indicted Paxton on multiple felony charges. One of the charges is reportedly securities fraud. So let's go live to Channel 8's Monica Hernandez. She is standing by live in McKinney following the new developments. Good morning, Monica.
Well, Alexa, the state's top prosecutor is waking up this morning knowing that he will soon have to surrender himself to jail and that his job and his law license are on the line. All of Texas waiting to see what's inside those indictments against him, and those are expected to be unsealed here at the Collin County Courthouse in just a few hours around noon today. But this is a fluid situation, and there could actually be a delay in Paxton's arrest. News 8 has learned that the original warrants aren't yet signed by a judge at the Collin County Sheriff's Office, and Paxton can't be booked until that happens, likely later this afternoon or even tomorrow. A lot of people this morning wondering what this will mean for Paxton's political career. Some are already taking to social media saying he shouldn't prosecute others when he is facing charges himself. But by law, he doesn't have to resign. Supporters say this is just a political witch hunt. Now, two special prosecutors and the Texas Rangers investigated the case against Paxton. We're told he is facing 2 felonies connected to a McKinney-based company called Servergy. According to the New York Times, Paxton is accused of convincing people to invest more than $600,000 in the company, but didn't tell them he was getting a commission for it, which is against the law. He also faces a 3rd-degree felony for failing to register with the state to sell securities. Now, Paxton's already taking steps to face these charges head on. He hired Joe Kendall, a former federal judge, to defend him. Now, if convicted on the 1st-degree securities fraud, Paxton could get a maximum of 99 years in prison. Now, that failing to register charge carries up to a 10-year sentence. And by the way, it's important to note that even though a Collin County grand jury indicted Paxton, he could turn himself into any one of Texas's 254 counties. Ron and Alexa?
All right, thank you very much, Monica. I will take it from here. This is a complicated case, and joining us now to shed some light on it is John Teakell. He's an attorney and former state prosecutor who has a background in securities law. So we hear the term securities here, and people may wonder who aren't investors what that means. Let's set up a hypothetical. I have some money I want to invest in a company. You're representing a venture. You come to me and you say, please invest in this. I've invested in it as well. And that becomes the deciding factor. I trust if you're invested in it, I'll give my money as well. Is that what is alleged to have happened here?
I think that's pretty much the crux of what happened. And as far as a security or being a security, understand that both federally and under state law, it's a very broad term. A lot of things, lots of investments can be considered a quote-unquote security. Usually it may just come down to the fact that it's an investment contract which covers all sorts of investments.
So there's a lot we don't know here, but let's talk about what the motivation or intent was, because that's really important to the case. If the Attorney General was intent on misleading people and that's why he didn't register, they would have to prove that, as opposed to it being an oversight. In how many cases that you've worked on have there been an oversight of this logistic of registering with the Securities Board?
Well, usually when you see a case that goes criminal as opposed to staying civil within the agency, whether it's the State Securities Board or the U.S. Securities and Exchange Commission, there's going to be some sort of fraud. Then you'll see additional counts such as failure to register as a security or even failure to register as an investment advisor. So the state, and as apparently the State Securities Board, deemed this to be egregious enough that it should rise to the level of being a criminal case, where there was criminal intent as opposed to just being some sort of oversight.
So this gives you some reason to believe, just on the surface, what we know so far, that there could be something more to this than just a failure or an oversight. But let's talk about some of the extenuating circumstances, things we don't know. What if the investors were happy? What if they gave their money and made money back? What if they don't have any gripes or complaints? Does that change the nature of this, the gravity of it?
Well, yes and no. If all those circumstances and factors existed, investors are happy, there was very few or if any losses, the case may not have become a criminal case to begin with. It may have just been an administrative or civil action within the agency.
So again, because this is a criminal indictment, you believe there's more to this than what appears on the surface to be an oversight?
There may well be, because this is very early in the process. I think the public is yet to determine or learn what losses actually there were and who he actually got to invest and whether there was a pattern.
That could be in that sealed indictment, which we are expecting in the next number of hours, and of course we will cover it very closely. We should note here, an indictment is an allegation, and many other political figures have survived indictments while they were still in office. So we will be tweeting all the details as it happens. You can follow us on Twitter at WFAA Channel 8. Our thanks to John Teakell, a former state prosecutor. Thank you much. Appreciate it.